Honorable Mr. Justice H.L. Gokhale, Honorable Dr. Justice S. Bimala, and all the other dignitaries, a warm good afternoon from Italy. At the outset, I would like to congratulate to Dr. Sampath, editor of Sattakadir, for organizing and hosting this global conference on law and justice. I've learned to understand that Sattakadir is the first and only Tamil journal that covers legal and human rights, issued since 1992, with global circulation in Canada, USA, UK, and several other countries. So, having myself co-authored in most recent past a book edited by Edward Elgar in European comparative law, I strongly believe that on the importance of creating awareness and sharing perspectives in order to shape today's legal world. As Sattakadir, under the able guidance of Dr. Sampath, has been rendering in a highly laudable way. At this juncture, I would especially like to thank Dr. Sampath for giving me this wonderful opportunity to share my thought on corporate law and economic development. So there is no dispute that law plays a key role in the economic development and a pivotal role in the growth of private business in particular. The importance of law and legal institutions for economic development is widely acknowledged. And when speaking about business, our first thoughts go first to commercial law and contract law, and of course, corporate law. But in order to gain a more comprehensive overview, we must look at the bigger picture. So before addressing to the specific issue of corporate law, I would like to go back on the issue of the rule of law. Finally, in order to make my speech more relevant and more tangible, I will focus on the concrete case of Italy and the recent Italian legislative reform in accordance with the European recommendations within the EU Next Generation Programme. I shall therefore divide my speech into three parts: the rule of law, corporate law, and the current legal reform in Italy. Why rule of law? Because good governance sets the normative standards for economic development, and good governance is strictly connected with the rule of law. The rule of law, also called supremacy of law, requires government to exercise its power in accordance with well-established and clearly written laws. The term was first coined in 1885 by the Oxford scholar Dicey, with reference to the principle of government by law. According to Dicey's definition, the rule of law is the principle that all people and institutions are subject to and accountable to a law that is fairly applied and enforced. He described the rule of law as having three basic requirements. First, the supremacy of law over arbitrary power. Second, equality before the law of all, including government officials. And third, constitutional law as the fundamental law. It is clear that the judiciary plays a particularly important role in a system based on the rule of law. And the former Vice President of India, Sri M. Hamid Ansari, in a speech delivered in 2016, claimed that the rule of law has been an important legal principle in Western countries and referred to the G8 Foreign Minister Declaration of the Rule of Law of 2006 and said that an essential ingredient of the proper governance and therefore of economic prosperity is the rule of law. So going now back to economic development, in the context of business, the rule of law establishes rules that people and corporations must follow in doing business to avoid being penalized. In commercial law, security of property rights, and integrity of contract fortify investment and trade, which in turn promotes economic growth and development. And this is true also for corporate law. As you all know, corporate law is the body of law that regulates legal entities that exist to conduct business. Corporate law deals with the formation and operation of corporations, so it is strictly related to conducting businesses. The literature on the connection between corporate law and economic development is massive. The main issue is corporate law rule as a tool of investors' protection. Greater investor protection is thought to make it more likely that people will invest, and thus increases the amount of capital available to business, which in turn facilitates economic growth. However, in this regard, there are many queries that require further discussion. For example, is it better corporate law that causes growth or vice versa? Much of the literature suggests that the relationship is not so unidirectional. Another question is, assuming improvements in corporate law cause changes in investment, are then those changes always rises in investment, or they can be reduction too? There is little study on this central issue in most emerging markets. Further, even assuming increases in overall investment, we could ask what parts of corporate law cause these increases, and do the effects differ depending on ownership structure, industry, jurisdiction, or what else? The literature provides some guidance, but as with many things in corporate law, much depends on the context. Yet another important question is whether the law per se matters, or is the likelihood of its enforcement, or how the law is interpreted by a sophisticated judiciary. There remain many questions still open that can be successfully explored in future research. But let's now focus on a concrete case, Italy. If you compare it to the USA, which has a corporate law that can be defined as enabling, permissive, Italy's mandatory terms in corporate law have always been more pervasive, but experience has shown that successful legislative policies are based on the presumption of permissibility. So prohibitions, limitations, approvals should be the exceptions rather than the rule. And in Italy, the picture is radically changing. Since 2004, Italy has enacted new rules for companies' formation, organization, and administration. This reform has brought Italian company law into line with that of other more advanced countries, introducing simplification. These new rules have replaced those which had been in place for 60 years. The key element of the reform is self-regulation, which allows companies vast powers to establish specific rules in their bylaws or in their act of incorporations or in their deeds, without many strict mandatory requirements. Overall, the 2004 reform successfully introduced changes in the structure of Italian companies, which simplify and speed up the procedures for establishing a business. Prospective foreign investors wanted to set up a business in Italy with a more permanent presence rather than establishing a mere representative office or a branch may decide to incorporate a company. Italy offers a wide range of investment vehicles for creating a corporate entity. The type of entity chosen will largely depend on the company's business model, the amount of capital to be committed, the extent of liability for its founders, and also on tax issues. Foreign investors are free to adopt any of the forms of business and titles available to Italian citizens. Types of business association may be classified in two categories, depending on the circumstance that they are organized on a stock capital basis, and we have capital companies, or on a personal basis, and we have partnerships. The difference between the two categories is that only capital companies are regarded as having a legal entity entirely separate and distinct from the individuals who compose it, with the capacity of continuous existence and having a faculty of taking, holding, and conveying property. A capital's company liability is normally limited to its assets, and the stockholders or quota holders are protected against personal liability in connection with the business of the company. There are two main types of capital company, and foreign investors usually choose one of these two structures to minimize potential liability exposure. Società per azioni, which may be deemed close to public companies in the UK or corporation in the USA, and società responsabilità limitata, which may be deemed close to private companies in the UK or limited liability companies in the US. Both types possess full and separate legal identity, which means that stockholders are generally not personally liable for debts of the company. And since 2012, a new industrial policy for economic growth and competitiveness has been implemented with the aim of creating favorable conditions for the development of a new business culture inclined toward innovation. The Italian government has enlarged the creation of a legislation intended to promote the establishment of a new innovative enterprise with high technological value. And this endeavor has culminated in a law decree in 2012 that is called Italy's Startup Act, and which has introduced into Italian legal system an innovative enterprise of high technological value. The innovative startup is not just a simple lawmaking exercise. In fact, it constitutes a comprehensive, coherent policy which regards innovative entrepreneurship as a key for industrial policy to follow. So now, bringing our brief review to the present time, it is worthy to note that the current Italian authorities, the Draghi government, has approved at the beginning of this year, 2021, a new plan called the RRP, Recovery and Resilience Plan, connected with the next generation EU aid. The European Union has made available 750 billion euros to support European countries' economy affected by the COVID pandemic. And amongst these resources, 210 billion euros have been allocated to Italy. This is a great opportunity. But what has Italy to do in consideration of this aid? What are we expected to do? Legal reforms. And this brings us back to what we argued at the beginning of this speech, the great importance, the centrality of the rule of law, and in particular of the process of reviewing the law with the aim of economic growth. With the RRP and its reform, Italy will be a fairer, greener, and more inclusive country with a more competitive, dynamic, and innovative economy. The relaunch action is connected to three strategic pillars: digitalization and innovation, ecological transition, and social inclusion. Reforms are the cornerstone of the plan. The reform framework of the plan, in line with the EU recommendation, aim to strengthen competitiveness, reduce bureaucratic burdens, remove constraints that have slowed down the investments or reduced their productivity. And Italy now has to avoid excessive barriers to market entry, and to do so, it is amending its legal rules which limit market access opportunity. So this plan includes reform of justice, both civil and criminal, reform of public administration, reform of some key elements of the tax system, and green and digital transition will be the core of this project. This vast package of reform will result into a concrete and significant increase in growth compared to the base scenario. By 2026, which will be the final year of the recovery plan, the positive impact on GDP will be equal to 3 percentage points. So, to conclude, this is a concrete and current example in which law, and more specifically, law reform, plays a key role in economic development. Law is not neutral. Law is an instrument of state policy which can be aimed at promoting economic development. As far as corporate law is concerned, what is needed is a legal framework that allows private business, regardless of where it is domestic or foreign, to grow and prosper. But the investor also needs a legal framework that is simple, certain, and stable. So it is important to review the existing rules, but when a satisfactory reform has been obtained, the state must stick to it and be consistent to ensure certainty and build investors' confidence. So this has been a wonderful conference. I have enjoyed listening to the talks on various topics, and I would like again to thank Dr. V.R.S. Sampath for connecting all of us in this virtual platform and for helping us to learn from each other most valuable information. Thank you for having given me the chance to participate to such an important event, and Vanakkam.